The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. We have 4 cases set before the court this morning. The first, one case entitled Struck versus Mercy Health Centers is hereby submitted without oral argument. The next 3 cases will have oral arguments. We'll take a break between the second and third case, just for a few short minutes. And before we start the first case, it's my understanding we have a group of middle school students here. Is that correct? Raise your hand if you're a middle school student. There they are. Thank you very much for coming to watch a public event. Yesterday we had a high school group here. So my colleagues roll their eyes at me, but I always like to make a connection with the kids who take the time to come see what we do. We're going to tell you what middle schools we went to. Mine's the same as my high school, K-12, Harlan, and my name is Susie Christensen. And we're going to go in order of seniority on how people were appointed to the bench. To my right, then to my left, and then we keep going all the way down the bench. So then you'll see the order of how we became justices.
Brent Apple, Washington Junior High in Dubuque, Iowa, a 7th through 9th grade school. Thanks.
Tom Waterman, Bettendorf Middle School, 6th through 8th.
Ed Mansfield, and I went to William Diamond Junior High School in Lexington, Massachusetts. I don't know who Mr. Diamond was anymore, but I'm pretty confident he fought in the American Revolution. That's generally what they name the schools after.
Morning, I'm Christopher McDonald. I went to McCombs Middle School here in Des Moines.
Good morning, I'm Dana Oxley. I went to Greenfield Middle School, which was part of the Greenfield High School, which is now Nottoway Valley.
Matt McDermott. I'm behind the TV screen here. I went to St. Angela's Academy in Carroll, Iowa.
So good morning, everyone. And I know the rest of the room had junior highs to report too, but we probably better get back to business here. Our first case is the case of State versus Pamela Middlekauff. And I wanted to first do a sound check quick. It's my understanding that Ms. Sears is going to participate remotely. Are you there, Ms. Sears?
I am, Your Honor.
Okay, thank you. And thank you for doing a quick sound check with me. And you are going to go first. And then when it's time for Mr. Howe, I am going to make sure you can hear him before I let him proceed, okay?
Thank you, Your Honor.
And can you see the time?
Yes, I can.
Okay, you may proceed.
May it please the court, Mr. Howe? This case isn't just about Pamela Middlekauff. It's also about the Missouri grandmother who will travel to Mayo Clinic in Rochester next week, bringing the medication her doctors recommended for the pain and nausea her cancer causes her. It's about the Iowa National Guard soldier who will drive across the river to visit his Iowa family for Christmas, bringing his PTSD medication with him. And it's about the college kid in Ames who can only safely drive himself home to visit his parents because Iowa cannabidiol suppresses his seizures. An Arizona citizen with a valid prescription for a non-opioid pain medication was convicted for having her prescription medicine with her when she drove through Iowa after a family member died. If the state prevails today, Ms. Middlekauff is a criminal with a record. If Ms. Middlekauff prevails, patients inside and outside of Iowa will be able to carry on with their lives enabled by their prescription medications.
I want to stop you right there. You're mentioning something over and over that I think isn't at issue in this case. This case does not involve cannabidiol, does it?
Well, Your Honor, the Iowa Cannabidiol Act specifically acknowledges that cannabidiol is marijuana.
No, it's a derivative of marijuana, but I want to make sure that we're on the same page. We're talking about buds and leaves and actual marijuana as opposed to cannabidiol in this case.
Yes, Your Honor. Ms. Middlekauff was in possession of marijuana flower, not cannabidiol under the Iowa definition. The Iowa definition, it does, however, say that marijuana includes all derivatives of marijuana, including cannabidiol.
Right, but our 124E defense talks about cannabidiol.
Yes, Your Honor.
There are 2 different definitions, correct? If you have a Venn diagram, cannabidiol is inside the marijuana. Marijuana is broader. It includes other things.
Yes, Your Honor.
Okay, so the question I have is, I know you have your client had an Arizona medical card, correct?
She did.
Okay, so if we would rule that that Arizona medical card is okay for her, it's okay for her to have had that marijuana with her, the buds and leaves or whatever it was, then aren't we also, what's the purpose of even having 124E in Iowa? Do we even need that exception? Because you're trying to say that that qualifies as a prescription.
Are you referring to the reciprocity in 124E.18?
Yes, that's what you're asking for us, is to treat her Arizona card as a prescription, correct?
Yes, under the accepted provision in 124.401 sub 5.
If
The
we treat it as a
reciprocity,
prescription, though, then why do we need the exception?
Because
there's always an exception for prescriptions.
yes, Your Honor, the reciprocity provision, in addition, it says we treat out-of-state cannabidiol cards the same as Iowa cards, except that out-of-state patients can't use Iowa dispensaries to access more medication. So rather than just providing a defense, it's more of a limitation. It says we'll recognize it as cannabidiol and that they can have cannabidiol, but they can't purchase it here.
Where does it say we will recognize marijuana as cannabidiol?
It doesn't. It says we'll recognize their cannabidiol cards as cannabidiol cards, but we won't allow them to purchase more cannabidiol while they're in Iowa. So they'll either have to leave their medication at home or bring it with them. There are at least 3 reasons that this court should acknowledge an Arizona medical marijuana card as a valid prescription. First, in passing the Iowa Medical Cannabidiol Act, Chapter 124E, Iowa created different standards for marijuana prescriptions than the standards applicable to other drugs. Second, treating an Arizona medical marijuana card.
This is Justice McDonald. Can you address the Arizona case of Dobson, where it's my understanding that even in Arizona, they don't recognize these cards as prescriptions. They're just
Yes,
authorizations to purchase at a licensed dispensary. So can you address that?
Yes, Your Honor. Arizona found that Arizona medical marijuana cards are not prescriptions under Arizona law for purposes of Arizona's prescription defense to OWI. This court should reach a different conclusion. Unlike Iowa, Arizona has a provision enabling Arizona's medical marijuana patients to advance an affirmative defense to DUI by establishing that the concentrations of marijuana metabolites in their systems at the time of a stop were insufficient to cause impairment. Additionally, unlike Iowa, Arizona law specifically differentiates between the impairing and non-impairing metabolites of marijuana. While in Iowa, any amount of any marijuana metabolite, whether or not it's an impairing metabolite, measurable in a driver's blood or urine, constitutes a per se OWI. In Arizona, DUI is predicated exclusively on impairing metabolites.
Ms. Sears, this is Ed Mansfield. I mean, these are kind of complicated arguments you're making, and also you're making in your brief. I mean, can't you just make a simple argument, which is the exception in 4015 says, if the substance was obtained directly from or pursuant to a valid prescription or order of a practitioner. Well, all you need is an order of a practitioner, right?
Yes, Your Honor, and that is another way.
So why are we, getting all involved in all this other stuff?
Well, you could interpret it as an order of a practitioner if you look at that as a term of art. And I do think I put in the additional authorities a district case in Texas where the court consistently used order of a practitioner and doctor's authorization interchangeably throughout.
You
So the
did
court
not argue
could-
that, though, did you? Everywhere
No,
in
Your
your
Honor.
brief that I saw, you have said that a prescription, this is a valid prescription, Supreme Court, and if you rule otherwise, that's unconstitutional. You didn't make that argument for order, the word order, and I do think there is a difference.
I think it is mentioned in there somewhere, but I did focus primarily on prescription.
So are you asking us to treat the Arizona card like a prescription?
I think that is a preferable outcome, but I think it would work either way.
Well, let's start with that one. If so, wouldn't the Arizona card violate what we require in our code for a prescription to include, and the things that it would be lacking in particular, and I'm looking at 155A.27. It does not include the name, strength, and quantity of the drug, and it does not include directions for use. How can it be a prescription in Iowa? Help me understand that.
Okay. Because under the Iowa Medical Cannabidiol Act, we've acknowledged that cannabidiol is marijuana.
Okay,
Iowa
for
Code
argument's sake,
section-
let's say they're not the same thing, just for sake of
Okay.
argument. Let's say they're not the same thing, and that's why I established earlier, we're talking about cannabis. We're talking about marijuana. We're not talking about cannabidiol in this case.
Correct. Okay.
So the cannabidiol provision you're referring to would not be relevant in this case, wouldn't it be?
Right. So acknowledging a medical marijuana card as a prescription would still be consistent with the common meaning of prescription. For example, at trial, a prospective juror explained during voir dire that she issues marijuana prescriptions to patients in Iowa, cannabidiol prescriptions to patients in Iowa. She indicated she prescribes cannabidiol for chronic pain patients as an alternative to pills in some cases because patients have been on opioid medications and become addicted or unable to function. And Ms. Middlekauff testified outside the jury's presence that her doctor had prescribed medical marijuana as an alternative to opioid pain medications, further supporting that a medical marijuana card is a prescription under the words common usage. Several of the cases the state cites even refer to marijuana prescriptions. They simply refuse to acknowledge that the prescriptions are valid. In Bruyette, the Wyoming Supreme Court referred to medical marijuana prescriptions or physician's orders under other states' laws, but Wyoming did not recognize legitimate medical uses for marijuana, and the court declined to recognize those prescriptions' validity. In Kuruc, K-U-R-U-C, the North Dakota Supreme Court referred to the defendant's, quote, medical marijuana prescriptions, but declined to recognize the prescriptions as valid because North Dakota didn't recognize any legitimate medical purposes for marijuana.
Ms. Sears, why would we look to other states for how they define prescription if we've got it in our own statute, how we define prescription? Why wouldn't we just use our own statute instead of what you referred to as the common meaning?
There are two problems with the state's reference to the sales and use tax chapter definition for prescription.
I know I'm
First-
talking about the pharmacy one on 155. Let me see where that is. No, I'm not talking about the tax one. I'm talking about 155A.27.
I'm sorry, 155A.27.
Right, sub 4. It categorizes 6 different things that a prescription requires in order to be called a prescription in Iowa. And I mentioned earlier the 2 things that are lacking, the name, quantity, and strength of the drug, as well as directions for use.
Right, so the requirements for prescription. That comes back to the cannabidiol argument. Would you like me to address that? If cannabidiol is marijuana, then Iowa has established different rules for a marijuana prescription in Iowa. Because the requirements in Chapter 124E aren't all compatible with the requirements of Section 155A.27 and 124.308 sub 1. And to the extent that those are irreconcilable, 4.8 requires that the more recently enacted statute prevails. 155A.27 and 124.308 sub 1 were both enacted in 1987, whereas Chapter 124E was enacted in 2017. Code Section 4.12 provides that statutes are severable. So to the extent that Iowa's Cannabidiol Act is incompatible with the requirements for prescription, we could still read it as a prescription.
Why would we need to? That's my earlier question. Why would we even need 124E? Or we wouldn't need it if the marijuana card is a prescription. In your argument, why would we need anything other than the statute we already have that says if you have a valid prescription in your body, that's not possession of a controlled substance?
Iowa Code Section 124.308 sub 1 prohibits dispensing prescription drugs that are controlled substances without prescriptions. Marijuana, including cannabidiol, is both a prescription drug and a controlled substance. So the problem there is that Section 124.308 sub 1 imposes requirements on prescription dispensation that are incompatible with the requirements in Iowa's Medical Act. For example, 124.308 sub 1 requires prescriptions to comply with Section 155A.27. You ran through some of those requirements. And Iowa's Medical Cannabidiol Act doesn't fully comply with those requirements. So to the extent that there are irreconcilable provisions, so 124.308 sub 1 says you need a prescription for controlled substances that are prescription drugs, and that would include cannabidiol. And then it lists requirements for those prescriptions. But those are incompatible with some of the requirements in Chapter 124E, the Iowa Cannabidiol Act. And to the extent that they're irreconcilable, the more recent one prevails. So we can pare away those requirements that don't fit and still call it a prescription, because 124.308 still can require a prescription. It just can't require those additional requirements.
Counsel,
that
I
are
want to
incompatible.
turn to a different question about the order from a physician. If I understand
Honor.
this correctly, under Arizona law, no physician actually orders marijuana as a medicine. The doctor just provides a medical opinion that the patient may have benefit from the use of marijuana, which then allows an application for a card. Is that right?
Yes, Your Honor. So Iowa Medical, oh, I'm sorry, go ahead.
So I guess where is the order? I mean, there is no order in this record from any physician directing her that she should purchase or needs to purchase marijuana. There's just a medical opinion that she may benefit from it.
Right. So if we treat order of a physician as synonymous more with doctor's authorization, then it's apparent that it is a doctor's authorization. She can't get it without a doctor's authorization. A doctor had to diagnose or confirm a qualifying medical condition, explain to her the various effects of it, and recommend it for an appropriate treatment for her condition.
Order is an ambiguous term, and we can say things like, I order Justice Apple to do something, or I order a book from the library. Those are two different uses of the term, right?
They are.
And we have a rule of lenity in Iowa, don't we?
We do. And I think the rule of lenity could dispose of this case.
Well, counsel?
Yes, Your Honor.
What is your best case that this certification that her doctor signed is an order?
So an order of a physician is a vague term, and it could mean a doctor's authorization. And she couldn't get that medical marijuana card without a doctor confirming that this is an appropriate treatment for her qualifying medical condition and authorizing her to do that. Without the doctor's exercise of discretion in determining that that was an appropriate treatment, she would not have been able to purchase marijuana in Arizona in 2019.
What role does the notice provision on the card play in this case? If I understand it correctly, there's a big warning on the card that says possession of marijuana may be illegal. You could be subject to criminal sanction under federal and other state law. Doesn't that put her on notice that if she's traveling outside the state of Arizona, then maybe she shouldn't be bringing the marijuana with her?
Your Honor, I think I'm out of time. Would you like me to respond?
Yes, please do.
Okay. So unlike in the Burns case, where the defendant had a Colorado medical marijuana card that stated on its face that this was not a prescription, Ms. Middlekauff simply said that it may not protect you under other jurisdictions' laws, which is an accurate statement. There are states, such as Wyoming, that don't recognize any legitimate medical purpose for marijuana, and under which she would have no protection from prosecution. My time is up. Thank you.
And when the state gets going, if you don't mind doing a really quick sound check to make sure Ms. Sears can hear you.
Test.
I can hear you. Thank you.
Okay, thank you. You may proceed.
Please the court. Counsel. This case presents a question of statutory interpretation, but lingering in the wings is another larger question, which is, in interpreting Iowa statutes, as Madam Chief Justice has pointed out, do we look to other states' policies to interpret it? The answer to that question should be no. Iowa Code Section 124.4015's prescription and direct order of a physician affirmative defense does not encompass the possession of marijuana in the state pursuant to a marijuana registry scheme, the likes that Arizona has. Also, I would say that Iowa has a categorical ban on the possession of marijuana in the format that Ms. Middlekauff possessed it. There is no prescription in any state that could have authorized its possession here. I want to touch real quickly because I feel that there might be some misunderstanding as to how these systems interact. Iowa Code Chapter 124 is our Controlled Substances Act, and it controls controlled substances, both prescription and illicit. Iowa Code Chapter 124E is our Cannabidiol Act, and it is a separate special registry system akin to Arizona's Medical Act, but different, that creates separate and different defenses and authorizations to possess a specific substance, cannabidiol, in the state of Iowa. 124-401, as I've noted, has treated marijuana as a Schedule I substance that in our legislature and Board of Pharmacy's views has no medical value in treatment. It cannot be possessed for medical treatment in the state at all.
If I find this certification is an order, what statute do you point me to that says that this defense under 124.4015 doesn't work? What is the statute that you cite to?
That is not an order? Excuse me, Your Honor.
If I find that it is, what statute do you point to saying, even if it is, marijuana can't be possessed in Iowa?
Absolutely. I would point to the fact that Iowa Code Section 124-203 and 204 treat it as a Schedule I substance. Even if there's a doctor's order to possess a substance, if it has no medical value in the state through our legislature's determination, it's still subject to penal sanction.
Why doesn't subsection 5 delve into that? Because subsection 5 just says if there's an order for it, it's okay.
And I guess, if you'll indulge me in a quick quibble with your decision to perhaps find it as an order, I think as your Honor's questions have pointed out, there is no directive on that form. It is merely a procedural requisite that they could experience some medical.
I want to go, if I need to get a computer, say, here at the office, I might go and say, can I get a purchase order for a computer? That doesn't command me to go get a computer. It's just an authorization that I can go get a computer, but everyone calls it a purchase order, right?
Well, Your Honor, we're dealing here in terms of art, and I think it's not always appropriate to jump to dictionary or colloquial definitions in that instance. I understand your point. It might be called a purchase order, but here we're talking about prescriptions, defined, controlled terms by the legislature, and to the extent a physician's order is a belt and suspenders clause or trying to encompass a situation where a doctor in the middle of an emergency room gives a directive to a nurse to go and obtain a controlled substance. This isn't that.
Would it be fair to say then, the position isn't whether this authorization is factually in order or not. Legally, under Iowa law, there can never be an order for a Schedule I controlled substance. Even if a doctor specifically said, I direct you to take marijuana, that's just void under Iowa law because it's a Schedule I substance, right?
Reason is because, oh, please.
Fact issue.
Why there was no error when the district court decided not to permit further instructions on this issue or to allow it to go in front of the jury. The legal question had been answered.
Back to, where is that, or how do I get to that in reading the first sentence of 124-401 sub 5? Because I think that, I mean, if this were for cocaine, right, it seems obvious that she can't have it. But if there's a prescription for cocaine, assuming that there could be one, from a different state, 124.401 sub 5 doesn't seem to say that it couldn't be, right, that wouldn't be lawful. And so how do I get there? How do I sort of, from the first sentence in 124.401 sub 5, get to this notion that there are a series of items that could never be part of an order?
I would suggest looking to our definition of what Schedule I substances are. Those are the types of substances that just cannot be prescribed and therefore cannot be possessed by individuals in the state of Iowa.
Valid. It says a valid prescription. It has to have meaning, otherwise they would have just said prescription. What do you think that means?
In this instance is something that the state would recognize. Wouldn't be contrary to our public policy, which again, in the state through our legislature and board of pharmacy is a flat categorical ban on substances possessed.
Prescription for opioids from an Arizona doctor would not be valid for someone to drive through Iowa?
And I want to be very clear in my answer. If we are saying that an opiate in this instance is, say, a Schedule II or a Schedule III substance, no, those are permissible. Our state's public policy would allow that to be a valid prescription.
And the Iowa code doesn't make that distinction.
I would suggest it's probably in Iowa Code Section 124.308, which states which prescriptions can be filled and administered in the state of Iowa, and Schedule I substances are not included in that. Therefore, we can reason that they are not valid prescriptions in the state of Iowa, and because we have a categorical ban, need not be honored when other states may effectuate them.
Well, consequences if the state loses this appeal, what are we going to see?
Basically render our questions going forward of what a prescription is, what a valid doctor's order is, subject to all 50 states and territories of the United States, however they change their policies. They're welcome to do so, but we don't need to honor their decisions. Even under a full faith and credit clause argument, which I don't think is fully fleshed out for the purposes of this appeal, but public acts of other states are not entitled to deference.
Legislature could have said that in the statute. It could have said something like, an order for a substance that would be legal to possess in Iowa.
I disagree with you, Your Honor. I mean, I agree with the idea that they could have, but I think they've already done so. When we adopted the Controlled Substances Act, we joined each and every state that at the time did so to create an interlocking trellis with federal law, not preemption, but something to mirror it so that controlled substances would be controlled interstate by the federals and intrastate by the individual states.
One issue I was getting at with Ms. Sears earlier, what do you say would happen in this situation if the defendant was carrying cannabidiol instead of marijuana and presented the same card?
If they presented the same card, I think we might have a small problem, and it would be whether or not that card, Arizona's registry system is distinct from our own. We would look to 124E to answer that question because it's cannabidiol. But without the card, for example, the prosecution would proceed as per usual through Chapter 124-401. So I would say 124E has specific defenses applicable to cannabidiol, but we would need to know and look at the card that you're presupposing.
4E, in your opinion, not even applicable in this case because we're not talking about cannabidiol?
We are specifically talking about marijuana, and in this instance, cannabidiol is a derivative, certainly, of marijuana, but we're not talking about the same thing for the purposes of this appeal and interpreting this statute. Also, I would note that the fact that both Arizona, Iowa, and a majority of states from my research that have adopted registry systems like this are specifically accepting them and creating distinct frameworks from prescriptions. They are not the same, and the reason I believe is because there is some consequence to prescribing physicians who recommend controlled substances such as marijuana in its complete form, which is why they take the form of these certifications that they could benefit.
Schedule I controlled substances, to what extent does Iowa law mirror federal law? Is it the exact same schedule of substances?
I believe there might be a minor distinction in that we might recognize a certain sub-derivative, but when it comes to marijuana in its pure state, we are on all fours with the federal system, which is that Schedule I.
Applies with the prescription or order exception under federal law. The Arizona card, at least as I understand it, would not be a defense to a federal drug possession charge. Is that right?
Relevant for the purposes of the appeal. During the course of my research, I found innumerable federal sentencing revocation proceedings where individuals try to rely on defenses to their probation being manipulated or changed because they were relying on their state medical marijuana acts, and the federal courts found no problem finding that they were still in violation of federal law.
Mirror our system? Okay.
Also treated marijuana as a Schedule I substance.
Based on the fact that it was not a prescription or because it was a control or a Schedule I controlled substance?
substance, Your Honor, because federal law simply won't honor those prescriptions, just as Iowa should not honor them here. We're our own separate sovereign, and we can control our borders and provide defenses as we see fit. This defense, if allowed, is contrary to our own public policy. I'd like to touch, unless there are further questions, on a few other issues that are in the case. I think this court should take the opportunity to reject on its face the idea that a trial information and minutes of the testimony that might contain facts that could support an affirmative defense should support the sort of litigation that went on here, trying to cut off the prosecution wholesale because the minutes of information didn't support a finding of probable cause. Affirmative defenses in this state should be pled, and then after some amount of evidence comes in at trial, barring any sort of legal determination like the one that was resolved here, then they will be entitled to the instruction. But we shouldn't be trying to cut off the prosecution at every step of the way and then re-raising it when we arrive at trial. It consumes resources, and also in this case, it has led to a slightly odd procedural setup where the critical question as to jury instructions was decided months before trial. I would also offer that the equal protection and void for vagueness claims in this case fail on their face. As you've touched on, Justice McDonald, aside from the fact that Iowa law, by its existence, gives notice to all, Ms. Middlekauff was clearly on notice that her conduct here would not necessarily be protected once she went beyond Arizona's borders. Her card warned her that using marijuana in other states might subject you to criminal sanctions, and the card would not provide a defense. I would also suggest to this court that as to the equal protection challenge, Iowa's legislature is free to distinguish between cannabidiol and marijuana as it sees fit. The two substances are not the same, nor...
Am I correct that marijuana causes hallucinogenic effects, but cannabidiol does not?
But I want to take your point and roll with it a little bit further, which is to say that one of the reasons that our legislature has taken the stance that it has is that marijuana does not have unified, standardized effects. It affects each individual differently, and as a plant, it does not have a standardized dosage. Some amount of marijuana in the same increment dealt out could be more potent, less potent. People don't know, and so the legislature, concerned about the non-standardized effects, and in addition to the questionable medical necessity, has decided that it is categorically banned until such time that the Board of Pharmacy decides that it has medical value.
I was talking earlier about the dosage is not included. If you want to call it a prescription, it doesn't comply with Iowa statute. If we were to follow the line of argument by Ms. Sears on behalf of her client, could this same individual carry a trunk load of marijuana and get a pass?
I would suspect that the county attorney in the example you're offering would attempt to look at what the native state's law is, but I agree with you. It's possible. I mean, she's asking for a categorical prescription.
What the dosage is. So if there's a trunk full, is there anything that's happened thus far in this argument to say that that case would be treated any differently?
We should look to the Iowa definition of prescription, which spells out the amount and instructions for use to avoid that kind of a problem.
I'm sorry. Go ahead. Make your point. You were responding to Justice Waterman. I interrupted.
Is their own lexicographer, and here they've adopted a thorough set in various instances defining what this term means. I think we should give effect to that and not look to what another state has adopted as a matter of their policy.
I want to raise the 4015 defense is only a defense to possession, not a defense to possession with intent to distribute, is it?
The hypothetical that was given to me, Your Honor, but you're right. It is only to possession.
Hypothetical. There's no dosage. That person could say it's for me. I need it all.
That's fair. I would also finally point out that as to Ms. Middlekauff's evidentiary challenges from the trial, I think it's unquestionable that it can be resolved either on the legal grounds or as harmless error. Ms. Middlekauff's advocacy throughout the entirety of this trial and appeal is that she possessed marijuana. It's not hemp. It's not something else. It's marijuana. She admitted as much to the jurors. So whatever question we might have as to a DCI agent's credentials or to their test or the chain of custody. There is no question left here. Ms. Middlekauff intentionally possessed marijuana as she traveled through Iowa, and that subjects her to our laws. Thank you.
Sears, you may respond.
Yes, Your Honor. I'd like to address a couple of the questions that were brought up. First, regarding a trunk load of marijuana, it requires that it was obtained validly pursuant to a prescription or a physician's order, and her Arizona card only allows her to obtain up to 2.5 ounces per, I think it's 90-day period. I could be mistaken. So there is an upper limit on the amount that somebody could obtain.
I know there's a day limit. Where's the amount limit? Is that on the certification or the card?
It is in the Arizona statutes. I don't have a citation to the appendix handy, but I do think I brought up that.
But it needs to be on the certification or card, doesn't it? To be an order or a prescription? I mean,
Well, it's not on the Iowa cannabidiol cards either. So no, I don't think that's something Iowa requires of.
Right, but we're not talking about
marijuana.
cannabidiol. We're going to talk about marijuana, remember?
All right. All right. And as far as the psychoactive effects of cannabis versus cannabidiol, having looked into it, it looks like, so marijuana has numerous cannabinoids in it. The most commonly known one is THC, which is the psychoactive compound. And then cannabidiol is often, I think we expect that it's just CBD, which is a different compound that's usually for pain and anxiety and that sort of thing. But looking at the dispensaries websites, the Iowa dispensaries websites, it looks like they have up to a 20-to-1 ratio of THC to CBD. So Iowa cannabidiol does include the psychoactive compounds of marijuana as well.
Counsel, let's assume there wasn't a affirmative defense in 124-4015. Would Iowa, in your view, be required to recognize the validity of the marijuana purchase as legal in Arizona?
Yes, Your Honor, I think so, under the full faith and credit clause, because the CSA has specifically provided that it does not control the field. And there's not, or at least there's been Arizona cases that have determined that there's not a positive conflict between the Arizona Medical Marijuana Act and the Controlled Substances Act, because they both further the CSA's
So it's your contention then that no state in the country has the authority to regulate controlled substances, and instead they have to be subject to the laws of other jurisdictions? So whatever
Not at all, Your Honor.
Well, I
Not
think
at
that's
all.
what
And
you just said. You said we have to honor Arizona's law, even if we didn't have an affirmative defense on 124-4015, right?
maybe I misunderstood you. I thought your question was whether or not we had to recognize that her purchase in Arizona was valid under Arizona law, which it is. What you're asking, I think Wyoming.
It seems to me the thrust of your argument is, well, this is legal in Arizona, therefore Iowa has to allow her to possess it regardless of what our own statutes say.
I think that her Arizona medical marijuana card constitutes a valid prescription or doctor's order under Iowa law, and that it was valid at the time she used it to obtain it in Arizona. So its validity is determined with respect to Arizona, or its validity at the time it was used is determined with respect to Arizona. And if that's not Iowa's intent, they can do what Wyoming did. While Burns was up on appeal, Wyoming passed an amendment to their accepted provisions, specifically providing that they would not recognize prescriptions for marijuana and that no physician could authorize prescriptions for marijuana.
But didn't we do that? We don't recognize in this state any prescription for a Schedule I controlled substance. There is no exception for that. So why does there need to be another law that just restates what the law already is?
Your Honor, my understanding is that in 2017, the Iowa legislature did acknowledge medical uses for marijuana. They've limited the forms that medical marijuana can be dispensed in, and they've put a cap on the amount of THC that a registered patient can obtain in a given time period. But they are acknowledging, Iowa is acknowledging that there are legitimate medical uses for marijuana.
And we've narrowed it down to cannabidiol. So I asked the state, and would you agree that we're not talking about 124E?
I think because 124E specifically says that marijuana includes all derivatives of marijuana, including cannabidiol, that means that cannabidiol is marijuana.
That's a definition,
So-
but the part that's the amount, the affirmative defense, which is what you're hanging your hat on, is for cannabidiol. They may have defined marijuana, but they didn't say you get a break for marijuana. They said you get a break for cannabis oil.
I think we need to distinguish 124E.18, which is the reciprocity provision, from the acceptive provision. Your Honor, I'm sorry, I think I'm out of time.
Anybody else have questions? Okay, thank you.
Thank you, Your Honor.
The case of State versus Middlekauff is hereby submitted. We'll take a brief transition break here. I understand the students may not be able to stay for the second argument. That's fine. And we'll get ready for the case of the estate of Linda Berry.